Derrybrien Wind Farm 13C. It's the 19th of November. You're very welcome back. This is not on the 17 series. It's on the 13, which is about planning and development. Although it happens to be a wind farm. They were fined 5 million, the government, for not complying with the Environmental Impact Assessment Directive, and €15,000 a day while it continues. Right, I'll try and stop the camera here now. So this is a report in News. I think they're a pro-renewable energy outfit reporting the fines. And the European Advocate General has suggested that the European Court of Justice fine the nation €11,000 a day, covering the period from 2008. ECJ ruling that no sufficient impact statement of the project was ever undertaken. So there's been more then on that. There's the Wind Watch, National Wind Watch, Derrybrien, how it all went wrong. So you'll get that there too. If you just search on the Derrybrien Wind Farm, how it all went wrong. And there are various other reports, and it was in the news and it was in the media. So I'll go back now to the now, in Irish planning law, there's a development. That's like a house, or building a bridge, building some kind of workshop, just for your own use. And that's under the Planning and Development Acts. And then there's exempted development. They're like putting up satellite dishes, certain glass houses, small glass houses, boundary walls, small things like that are exempt. And strangely, underground cables without any restriction on their length are exempt. In a way they're exempt. But then if they have an impact on the environment, or if they're connected with a wind farm or other major effect, they can be screened to see if an EIA, an environmental impact assessment, is needed. We'll not dwell on that for now. So you have a development, Planning and Development Acts, local council grants permission or refuses it, and Bord Pleanála is the appeals board. You have exempted development under that. Now, an exempted development cannot exist if it needs an EIA, or I think possibly an appropriate assessment under the Habitats Directive. I just won't go into that at the minute. We'll stick with what I know fairly well. Now, after development, the next thing you have is a project. And a project requires an environmental impact assessment. And under the EIA directive, which came out in 1985 and was updated in 2011 and was updated again in 2004. So under present law, if it needs an EIA, we call it an EIA, get used to that term, the developer puts in an environmental impact statement, which was before 2014. Now it's an environmental impact report. An environmental impact assessment report, I think it is. It used to be an EIS. Now it's an EIA report. Doesn't really matter. He puts in his report. It's the developer does it. The planning authority carries out that assessment, whether it's the council or on Bord Pleanála. They carry out an assessment of it and check that everything's right, and the public have a right to participate when all options are open under the Public Participation EU directives. Okay, and that's written into the EIA Directive Article 6. Now, so far I may have blinded you a bit with science and with law. I don't really mean to that. Above that then is there's a public plan or programme, and that comes in under the SEA Directive, the Strategic Environmental Impact Directive. And that's the sore point with me and many of those on my side in the European Platform Against Wind Farms, which I am the Irish spokesperson, is that they didn't do the SEA on wind. Article 3.2 says that Strategic environmental assessment shall be carried out on all plans and programmes for forestry, fisheries, energy and a whole lot of other things, town and country planning. And they didn't do it. And we have a sore point over that. It's gone to the Arthur's Compliance Committee. The Arthur's Compliance Committee has ruled on several occasions Ireland is a breach of its responsibilities under the directive and under the Arthur's Convention to allow public participation in environmental matters. So it's corruption. Our government is corrupt. Simple. But we go back below that now. We have the 3 tiers, remember. Public plan or programme, a project, a development. There are 3 different things. Now, forget now about the SEA, forget about the public plan or programme now for the moment. I won't be going back to it now in this video. The next thing then you have, how do you know if an EIA is needed? And the annex to the EIA directive, which is also built into the regulations on the Planning and Development Act where it applies, is that they're stated in Annex 2. They're stated what is required. And they're usually smelters, large pig farms, and several other things. So there's certain things which need them no matter what. Nuclear installations for generating electricity by nuclear power. They need an EIA, full stop. Kibosh. There's a big long list of things, just what you'd expect. Smelting iron, smelting aluminium, smelting copper and all that. All that sort of stuff. Now, then you have a sub-threshold, which it needs an EIA if it's above a certain size. And wind farms of over 5 megawatts or with more than 2 wind turbines required. I think that's what's in the annex. But wind farms most wind farms except small ones require it. Small wind turbines don't. And if there's only 1 or 2 of them, you can have them with just a development application. But if they're the ordinary wind farm, they need it full stop. Now, the North-South Interconnector needs an EIA as well. Because of its size, and there was a point raised about the North-South Interconnector. If it went underground, because there's an exemption, would it need it? Well, it would, because the EIA directive says that it has to be screened, and if the project has a significant impact on the environment, then it has to have an EIA directive, assessment, and the planning authorities could be taken up for judicial review if they didn't carry out an EIA. Now, I know I have you a little bit confused there. Now, I just want to mention to you a thing known as the O'Keefe Principles. And the O'Keefe Principles are that if the directive is breached, the court has to intervene in a judicial review. But if the planners comply with the directive and they do all the considerations that's necessary and arrive at a decision which is ludicrous, which you suspect they were having all drunk on drugs and everything else, you have to have a very high threshold. You have to show that they were behaved totally and utterly irrational if it's the decision they make. So if they sit down and make a decision, having complied with everything and having assessed all the various points that are brought up, and they cover all the dots and still come up with a ludicrous decision, then you can't really challenge them. You won't win with a challenge in a judicial review. Now, if they had a ruling that expected water to flow uphill, that would be a very good example where you might win. But just to understand that, if the procedure's not followed and they don't consider the points that are relevant and the points that are raised, then you have a good chance of winning in a judicial review. And I think down in Laois there's a wind farm at the moment where the effect of the pearl mussel is being considered in a reserve judgment. The case is over. The judge put back his verdict or his judgment. But the issue there is, did they consider the impact on the pearl mussel? If they did consider the impact on the pearl mussel and came up with an opinion and a result, I think the Bord Pleanála will win. On the other hand, if they didn't consider the impact on the pearl mussel, the residents will win. Do you understand? If they follow the procedure and make a ludicrous decision, it's difficult to overturn it. If they don't follow the decision, the procedure, it's easier to overturn it. That's the O'Keefe Principles. And that was something that was very important in the Northeast Pile and Pressure Challenges, and I'll deal with that at another stage. Now, I'm at 9 minutes, I think it is. Yeah. Now, I just want to go back to Derrybrien. Of course, no, the state didn't want to do any EIAs. I went in with other people to Cavan County Council in 2011, and the people who made the decision here on Rara Wind Farm and Tahard Wind Farm told me they hadn't a clue what the EIA directive was. They said it was resources, they got no training. Here were two lady planners who admitted they hadn't a clue the directive existed. And this is the standard you have. And it was the same with Bord Planola. What a rotten system, where Bord Planola didn't even know it. Now what happened was, over the years, they were forced to comply with the regulations by communities saving up and paying specialists. I normally don't name people because it's dangerous, but I will name one man, Peter Sweetman, over in the West, and he does this type of thing. He makes a submission and he does all for people. He charges something for it, I understand. And when it comes to the EIA directive, he's excellent. And when it comes to the Planning and Development Act, he's excellent. I don't agree with him on the SEA. He and I disagree about the SEA where it applies, but I took a judicial review. I didn't win in that. We'll deal with that again. But he's very good. So he has had an effect in making them comply. Another man was David Malone down in Offaly. I think he's Port Arlington. He had a group called Environmental Action Alliance Ireland, and he had great knowledge of this, an unbelievable knowledge. His problem was, unlike Peter Sweetman had lawyers that you could hire if you had the money. And I know one group had to collect up something like 40,000 down the south to get lawyers. And whereas David Malone didn't have lawyers, and he did the groups who were employing him couldn't afford lawyers, and he was stuck with that, and that was a big problem. And yet his knowledge of these directives was breathtaking, and I associated with him, and I have to say a lot of what I know I got it from David, and he still is a great man to advise if you had a group who had the money. And Peter Sweetman's good as well. And then there's another man called Peter Crossan, who up in West Cavan, who does very good work there. And I'm sure there are other people there as well. And they study it, and they're very, these people are very, they're not cocky type of people. They study and they read and they come up with their own way and they have their own approaches, and each one might differ slightly. But you have to pay them some few bob. If you can, and this is the problem, some communities don't have this. This is the shame of this, and this is the scandal of what our government is doing with our corrupt stuff. So I maybe should have named other people. I don't know. They're in the business anyway, and they're very good. I don't think they'll mind me mentioning them. But what they've done is they've forced the planners to at least do some type of an EIA. But for years they were doing nothing. They were doing absolutely nothing. In fact, I don't know, was there even an EIA on most of the early wind farms and other things? Quarries and everything else, and no EIA. Now they have to do it. It's unbelievable. Even I took a judicial review on the Rara wind farm. They didn't want to do an EIA on the cabling. They wanted to say it was exempted development. I had to go through the whole process of challenging them on my own. And it wasn't easy, and they served me with a car trailer load of documents, nothing to do with the real thing, and I stuck to my guns, and with a bit of help from that man David Malone and a few others, I went up one day to fight my case, and here Bord Planola caved in and paid me my expenses. To over €2,000 I got, 2,200. I even got me cups of coffee and all out of them. But you don't get your legal fees for your expertise. You just get your expenses for your out-of-pocket expenses. But it was good to beat them on it and make them do the EIA. They did it and they got permission after. But at least we made them do it. Now, at the time of Derrybrien, there may have been an EIA. I think there was an EIA. The residents appealed to Bord Planola, and of course Bord Planola granted permission. It was Sergas was the people at the time, and they never assessed the possibility of the peat moving down off the mountain. They never assessed the killing of the fish. 5,000 fish were killed. I think they were trout. What a scandal. What a green mess. This is what the Greens, the Green Party, Fine Gael, Fianna Fáil, Sinn Féin, this is what they want. Oh, we'll build wind. And that wind farm got a bailout by the ESB in 2017 of €10.1 million, and it's losing money hand over fist. And the Irish government, through our taxes, were fined €5 million and 15,000 a day. Now, the big surprise is that the European Union did anything. I can't believe they did. because they won't insist on the enforcement of the SEA directive, because they too are corrupt. And they have barriers in the way of the ordinary citizen challenging them, which is corrupt. And I'm very bitter about that they don't comply with the law. I supported and voted for the European Union on the basis of what was put before me, before the Lisbon Treaty, and they have reneged on it. They have cheated on it. When they got the vote, they kicked us in the face on the environment. Okay, enough of that for a rant. Now I want to tell you at 15 minutes, and I'll soon be gone, the problem. The problem is that in 2011 the Planning and Development Act was amended and they inserted Part 10. Now up to that it was kind of to shove in the EIA, the EIS and the Environmental Impact Assessment and the Habitat Assessment with the planning and let the whole thing churn up like a mixer, But they brought in Part 10. Section 172 of the Planning and Development Act, and you can Google it yourself. It's Planning and Development Act Revised Acts is what you want to look at, and it'll drive you barmy, it'll drive you mad trying to study it. Even I find it tough by times. But in any event, they brought in Part 10, and when the planning application is lodged on the form under Section 33 of the Planning and Development Act, if it requires an SEA, the planners have to screen and see does it need it, and if it needs it, and sometimes it's automatically needed because it's in the directives and it's in the regulations which copy the directive. If the EIA is needed, then it sets out the procedure of how the EIA is done. So you cannot have an environmental impact assessment carried out apart from the Planning and Development Acts. There's no procedure to carry out an environmental impact assessment other than as an application for planning permission. Do you understand me now? So you can't independently do an EIA. You make your application under Section 33 of the Act. There's a form for it. You fill it in with a biro, funny enough, all right, and you send that in. And the developer himself can decide an EIA is needed. He can be automatically realise it is if it's a big wind farm or something, or like the North-South Interconnector. It's beyond dispute. But if there's a doubt about it, then it could be that a screening is required to see if it has a significant impact on the environment. So even a hotel or even a few houses being built in a country area, if it's a sensitive area, could actually require an EIA. It's up to the planner to decide at the screening stage whether an EIA is needed. And it's to do with an assessment. And again, if they do the assessment and do the screening and they decide it's not needed, then it's very hard to overturn that. If they decide it is needed, then an EIA has to be done. But in most cases, the case of Derrybrien Wind Farm, there was no doubt. It was in the annex, it was in the regulations. An EIA was needed for the Derrybrien Wind Farm. They did a Buckshee one at the council level with Galway. They did a Buckshee one at Burplanola level. The people were ignored. They granted planning permission. They never assessed the fact of what had happened to Pete or anything else. They didn't do it properly, and a disaster took place. An absolute disaster. An environmental disaster. Of a wind farm that had to be bailed out to the tune of 10 million. Just think of that. So a disaster took place. And the EU, for a wonder, pursued them and fined them 5 million and fined them 15,000 a day. But the problem is they cannot repair it. The only way to fix that is to close down the wind farm and close down the facility. And even then I'm not sure if that will comply. And the reason they can't fix this is that the only way you can do an EIA is under Part 10 of the Planning and Development Act. There has to be an application from the applicant, and the result of that has to be that the wind farm planning would be refused. So Derrybrien Wind Farm would not be granted today because a judicial review in the Irish court by anybody would automatically say no, there's a danger of the peat falling into the river and into the roads. So it's there. It should never have been granted planning permission. We, the taxpayer, are paying €15,000 a day, 5 million if a fine up front, and the thing can't be fixed. And funny enough, if our government had any brains, which they don't, because they're gob beans, if they had any brains, they could make a case to the EU that it's impossible to repair this. In other words, that defy natural justice, because it can't be fixed. The peat is gone. It can't be restored. Under Irish law, which complies with the EIA directive, you can only do an EIA as part of planning, as part of a planning application, and the end result has to be a grant or refused. So how do you refuse a grant of a wind farm that's built in 2006? Built in 2006 is 13 years old. It'll soon have to be closed down in any event. So it's a mess. They don't have the brains to argue with that. It's unbelievable that I am paying tax to pay a fine on this. That people can be forced to pay tax. This corruption is so endemic. And it's so sad that all this can happen. So I think I've explained that now at 20 minutes. Just again, they can't repair the EIA now because it was done in 2011. It wasn't done properly. The EU has stepped in and fined us. They're fining us for continuation. The only way you can do an EIA is but an application for planning permission for a project. Under Part 10 of the Planning and Development Act, Section 172, the environmental impact report would have to be filled in, and the planners would have to consider it, and the end result would be they refuse permission for Derrybrien Wind Farm. You cannot make the ESB, who are the current owners of Derrybrien Wind Farm, apply for planning permission when they already got it. That's the dilemma. There is no procedure to do an EIA outside of a planning application in Ireland. And I don't know is there anywhere else. It was always envisaged that this would be a more stringent assessment carried out parallel with the ordinary planning process. And when the EIA passes through all the stages, the final result is that the planners, the Bord Pleanála as it would be, decide that it passes the EIA and they grant planning permission. The EIA has to be satisfied. The appropriate assessment under the Habitats Directive has to be satisfied. And then the grant planning permission. And then that's subject to judicial review in the High Court and right through to the European Court of Justice. So that is the procedure. But once planning permission is granted, there's no going back unless a judicial review. And if no judicial review is taken or the judicial review fails, up goes the project. It's built, and then we see what happens. The inadequate EIS was carried out. It's unbelievable that we're still building wind farms on mountains and destroying grouse moors where there are grouse. These birds survived the Ice Age. They're still here from the Ice Age. They're being driven out and destroyed by these blasted, damned wind farm mania that we have. So folks, it's 22 minutes. I hope I've explained that again. I repeated it a few times. The Derrybrien Wind Farm. I hope now that you understand that the Environmental Impact Assessment Directive came out in 1985 and is still in existence, and it's a higher standard. It's for the project. It has nothing to do with the overarching planner programme. It's to do with the local project at local level, this individual project. So that's it. That's my bit on developments, and hope that will help you. Sorry for the long video again. It's very hard to keep these to shorter time. Bye bye. We'll see you back then for something else. And please, if you think I've explained that fairly well, I went to a lot of trouble with it and the one on the underground indicator. Just give them a thumbs up or a thumbs down, whichever you want. Just something to let us know on, and pass them on and encourage people to look at them. Thank you very much. Bye bye.